Good evening, friends. Let us discuss rights of minority institutions, how they are protected in India. Friends, Article 30, right of minorities to establish and administrate educational institution. There is provision of Article 30, which defends minority institutions. It says that all minority, whether based on religion or language, have the right to establish and administer educational institutions of their choice. In case of acquisition of such institutions by the state, compensation must be paid. The state shall not discriminate in granting aid to educational institutions on the ground that it is under the management of minority. Now, let us discuss landmark case laws on minority institution protection. Firstly, is reference Kerala Education Bill of 1957. Issue was whether the Kerala Education Bill violated the rights of minority institutions under Article 30. Honorable Supreme Court upheld the right of minorities to establish and administer institutions. However, administration does not mean absolute immunity from regulations. Reasonable restrictions in public interest are valid. Then St. Xavier's College versus State of Gujarat. Gujarat University tried to regulate the selection and appointment of teachers in minority institutions. Honorable Court struck down the regulation. It ruled that autonomy of minority institutions in administration is an essential part of Article 30 and cannot be unnecessarily interfered with. Third is TMA Pi Foundation versus State of Kerala. A 11-judge bench clarified the scope of Article 30 and minority rights in education. All citizens have the right to establish and administer educational institutions under Article 19, Subclause 1, but minorities have special protection under Article 30. Minority institutions can have their own admission process, but reasonable regulations are allowed. Private, unaided institutions, including minorities, have more autonomy compared to aided ones. Then comes the PA Inamdar versus State of Maharashtra, that is of 2005. The court ruled that the state cannot impose its regimental policy on unaided minority. This reaffirmed their autonomy in admissions and administration. Now, next is Paramati Educational and Cultural Trust versus Union of India, that is 2014. The Supreme Court held that RTE Act does not apply to minority institutions as it would interfere with their right to manage their own affairs. So, nutshell conclusion is our Indian Constitution, backed by judiciary, provides strong protection to religious and linguistic minorities institutions under Article 29 and 30. However, this right is not absolute. It is subjective to reasonable regulations, especially in aided institutions. That's all. God bless you all.